Amend this bill to the House. Thank you, sir.
Call Dennis O'Rourke.
Thank you, Mr Speaker. With only a couple of reservations, New Zealand First supports and welcomes the Patents Bill 2008. Clearly a bill a long time in gestation, but it is good to see a bill to replace the Patents Act 1953, which is obviously outdated and not compatible with some overseas legislation, modelled as it was on the earlier UK Act of 1949. The 1953 Act has a low threshold for patentability compared with other countries. Therefore, broader patent rights were available here than elsewhere. So technology freely available elsewhere might not be available here in New Zealand because of coverage by patents. This could, of course, damage New Zealand business innovation, damage business growth and productivity, and also restrict consumer choice. Mr Speaker, the bill will modernise and upgrade patents law in New Zealand. Part 5, as we know, has been split away from this bill and will now form part of the new Patent Attorneys Bill. The new Patents Bill now being considered will be good for New Zealand business for the reasons I've already mentioned, and it will align the New Zealand law with international practice, and so it should. It will strengthen the criteria for granting patents in New Zealand to an absolute novelty standard, so that a patent applied for here will be examined for usefulness and for the presence of an inventive step. So while patents will not be available according to the broader regime previously available, the new standards applicable will ensure, we believe, better patents, better products, and therefore a better outcome overall for New Zealand business. It's a very large and comprehensive bill, developed since at least 2008, and we think that the Commerce Select Committee has done a great job with it over that period of time. For those reasons, the bill fundamentally deserves support, with only a couple of reservations, which I'll come to in a minute. The main changes recommended by the Select Committee, as I say, with a couple of exceptions, are supported by New Zealand First. They add value to the bill as presented, and these include some important exclusions from patentability in relation to public order and morality, by adding some examples which I note are a process for cloning human beings, a process for modifying the germline genetic identity of human beings, an invention that involves the use of human embryos for industrial or commercial purposes, and an invention that is a process for modifying the genetic identity of animals that is likely to cause them suffering, and so on. Those are very good examples, and it's a good addition to the legislation as recommended by the committee. And then there's a very clear requirement in section 37(1) for the description of inventions using the words, quote, disclose the invention in a manner that's clear enough and complete enough for the invention to be performed by a person skilled in the art. Further, the recommendations preserve pre-grant opposition rights, which we agree with, and provide in a new section 138A for protection against infringement proceedings where a person had been continuously exploiting an invention immediately before the priority date. Such a person would be allowed to continue using the invention even if another person or company obtained a patent for the invention without being subject to infringement action. So we think those are all very sensible additions to the legislation. However, coming to the reservations which we have, we also believe, as the Labour representatives have stated, that the new sections 10A1 and 2 are problematic as recommended by the Minister's amendment, which frankly seems to me to be complete gobbledygook. And I believe that the SOP number 123 provides for a much better alternative, in that it states subsection 1 does not prevent an invention that makes use of an embedded computer program from being patentable. And when you compare that with the amendment recommended in SOP 120, which says subsection 1 prevents anything from being an invention for the purposes of this Act only to the extent that a patent or an application relates to a computer program as such. To me, that is very problematical in that it is capable of a number of different interpretations. I think I know what it means, but I'm sure that there would be others who would have totally different interpretations at all. So, from a completely clarity point of view, I think SOP number 123, the amendments in that are much better. New Zealand First also supports SOP number 124, which is introduced by the Green Party, concerning the non-patentability of organisms, whether genetically modified or not. We think that's a useful addition which should be incorporated into the bill, and we will therefore support that amendment for those reasons. And, Mr Speaker, otherwise the recommendations of the Select Committee are supported by New Zealand First, as is the bill as a whole. As I said at the beginning, I think this will update and improve New Zealand patent law, make it compatible with overseas countries, and be a good template going forward for people in this country who rely on patent rights for their business and for the economy, therefore, of the country as a whole.
Point of order, Claire Curran.
Mr Speaker, I seek leave to table the petition No Software Patents in New Zealand, signed by 1,078 New Zealand software companies and sole operators, including Xero, Jade and Orion Health.
Leave is sought for that purpose. Is there any objection? There is no objection. I call Mark Mitchell.